One is now in session.
Thank you. Please be seated. Good morning. We're here for oral argument in 1 CACV 210049 CRST International is the petitioner, Indemnity Insurance Company of North America, petitioner's insurance carrier versus Industrial Commission of Arizona, with Gordon McChesney as respondent employee. These proceedings are being video and audio recorded, and actually I think live as well on YouTube now. So we ask counsel to please identify yourselves and your client before you begin your argument. Counsel, you know that you each have 20 minutes. Appellant's counsel is responsible for watching the clock to reserve a portion of that time for rebuttal if desired. We have read the briefs and we have discussed this case at conference. So with that, counsel, you may proceed.
Thank you, Your Honor. May it please the court, my name is Eric Slavin. I represent CRST International and their insurance carrier. And now we're here on a workers' compensation claim in which the Industrial Commission, through its administrative law judge, granted benefits for a claim that we have protested by filing a petition for special action. In this case, our allegation is quite simple in that we believe that the injured worker was not in the course and scope of his employment, which is required under Article 18, Section 8 of our Constitution. It can't just arise out of it in terms of but-for causation, but must occur in the course and scope. There is an expanded view of what course and scope is for people who are traveling, but it is also a limited doctrine. It is not so open-ended so that anything that is done of a personal nature is covered. And in this case, Mr. McChesney was doing a personal errand and therefore should not be covered. I think the best case that really spells out the difference between what should be covered and what should not is in this court's opinion in Peterson, where it distinguishes between what happened in there and why that case was covered and why an earlier case that they cite to called Edwards from the Arizona Supreme Court was not covered. In both cases, the employee was traveling and traveling overnight. And in one case in Peterson, they said that was a covered injury because Peterson was sleeping, which was necessitated, not as a voluntary thing to do a personal errand, but necessitated by the fact that his employer had him be there overnight. And therefore, it served the employer's interest for him to be there and to sleep. And so the fact that he died when his head was caught in the bed slats of his headboard while sleeping, which was something that he was perfectly there to do and should have done, meant that his injury was covered. By comparison, they look at the Edwards case from the Supreme Court, in which the claimant was also on an overnight stay, also died while at the hotel, but died from drowning in the pool. And they said he was not doing something that was necessary for him to be there, and it was not there to benefit the employer. So you've got to have those elements in order for an out-of-town injury to be covered. And so that's the distinction that the Peterson court makes compared to the Edwards court. And so I think that is the distinction here, which is it can't just be that if you're out of town for your employer that everything that you do is covered. If you're doing a personal errand, you are still not covered. And that is what happened here. Mr. McChesney was going to do a personal errand to do some shopping for his dog, and that's perfectly fine, but that does not serve his employer's interest. It was not a necessary thing like eating or sleeping. So that is the distinction here. Yes, Your Honor. So
this, it really is a fact-intensive inquiry, isn't it?
It is.
And so in this particular case, Mr. McChesney would have been permitted to go into the Walmart to use the restroom if necessary?
Yes, because that is a necessary thing for him to do. It is generally considered for things that are necessary, such as eating, sleeping when it's an overnight trip. That wasn't the case here, but that's what Peterson talks about and many others. And also eating. That's what Bergman's Precision talks about. The claimant was traveling although locally, and had to stop to eat at some point during the course of the day. That was necessary for him to be able to continue working. You've got to be able to eat. If you're overnight, you've got to be able to sleep. But if you're running a personal errand, that is not something that is there for the benefit of the employer, and that is not something that is necessary.
And so he would have, as you just stated, been able to go into the Walmart to pick up some lunch for himself. So he was not absolutely forbidden from going in the store.
That's correct. And the analysis really is, what was the purpose of the trip? Was it purely personal and doesn't do anything for the employer as well? It's not incident to the employment, or is it something that is a purely personal thing? And if there's that distinction, which is clear in this case, then the claim should be denied. If he was in there doing something like lunch, or if bathroom, or let's say he was a diabetic and needed to pick up medication so that he could survive the rest of the day, then those are things that are considered essential, and what in Peterson specifically says necessary. And
okay,
that's the key.
So continuing with that line, in terms of essential things to do, so Mr. McChesney lived in an area where he would have been home very late and potentially not been able to pick up food for his animal after he got home, or at least that's the position he's taken, right?
My understanding is dog treats, not dog food, so the dog wasn't going to starve if he did not pick up treats for his dog. And even then, that's necessary for the dog and not for Mr. McChesney. But
let's go back to the fact that he was delayed in the start on that particular day of his shift, or actually of his trip, not the shift, but the trip due to some repairs that had to be made. So he was running short on time, as we understand it, and it would have taken longer and more time out of his work time for him to have walked from the back of the store all the way to the front of the store. It probably would have consumed all of the time that he would have had for a reasonable break. Isn't that fair to say?
Yeah, it's fine for him to have done the errand on his break. It's just that he was not working while he was doing so.
Well, it goes to the point that wasn't it a benefit to the employer that he get to the front of the store the quickest way possible rather than walking over there?
No, he used his employer's conveyance in order to do so. That actually is a deficit to the employer because he used that for his own personal use rather than for the benefit of the employer.
Right, but my question is, had he been able to get to the front and in and out of the store and back without the accident that occurred, would he not have saved his employer time by using the conveyance rather than walking?
It depends on how fast he walked versus how fast that conveyance went.
Didn't the conveyance go like 11 miles an hour?
It could. People can run faster than that, Judge.
Is there any evidence that he's able to run?
We have no idea. He is. I know he was quite injured. He is walking. I don't know how fast he could walk or run. I know that just as a general matter, people can run quite a bit faster than 11 miles an hour.
What about more generally about the overnight, the rule that has traditionally been applied for overnight traveling workers, but I believe the Bergman case actually applied that to a person locally traveling.
Yes,
if I'm not wrong. But just generally speaking, I mean, aren't we in a little bit different realm? I mean, you've got where people have to live their life while they're working. I mean, they're expected to be out there. He's expected to leave the Tolleson plant or leave Chandler, go to Tolleson, begin the day, and then be back within a certain time frame, if I understand correctly. I mean, he's on a limit every single day to work within that time frame. Is that not correct?
Generally, yeah. I mean, the question is a necessity. Bergman's talks about that there really isn't a substantive difference between the person who travels and stays overnight and the person who's traveling locally.
Right, and so the person, why did the person jaywalk? Was that to save a little bit of time? Why do you or I jaywalk? Isn't that to save a little bit of time if I do that outside here at the courthouse?
It could be, or it could be for some other reason. It's not clear from Bergman's, but they said that because there's a couple of things going on in Bergman's. First of all...
But how is jaywalking not a deviation?
Well, and that was the question because he was going between lunch, that the court determined was fine to consider because it was necessity for him. So they said he is still in the course and scope while traveling and having lunch because that is necessary and not considered to be a personal errand. So second, I believe the case indicates that he took 2 work phone calls during that lunch, so he was working during that lunch. And then when he's going and crossing that street to get to his car, it was to not go home so that it's a commuting situation, it was to go to his next job. And so therefore, the only time where he is anywhere is when he's crossing the street to go from work-related lunch to work-related travel in his car. And so there is a direct connection in that even while he's jaywalking, he is still doing his employer's work. He is still going between the work lunch and the work car to travel for work.
And Mr. McChesney's day was not over yet, wasn't it?
Yeah, that's correct. But again, not relevant because he is taking a personal errand, which is a deviation from
Counsel, let me ask you about that. The ALJ noted that he testified he went to the store to get dog treats, but that he might have grabbed something to eat or drink when he got inside as well, correct?
Right, but might is not, that was probably the basis for the trip. The basis for the trip and the reason he went there was, and not disputed, was to get treats, and if he was there, he might do something else.
Let me ask this, though, and we don't know because he was injured on the way to get into the store. But if the primary purpose of going to the front of the store to get in was to get something to eat or drink, would your argument be the same as it is today?
No, because then he would be eating just like in Bergman's while traveling. And since eating is necessary in order to survive the day, just to be able to have enough calories to be able to perform your work, to get drink, especially in the hot climate that we have, that would take it back within the course and scope of employment because it is a necessary thing in order to be able to continue doing your work.
And let me ask you another hypothetical. And again, this is different than
sure.
than the record. But what if instead of saying, hey, the primary purpose was to get dog treats and I might have gotten something to eat or drink as well, what if instead the testimony was my primary purpose was to get something to eat or drink, but I might have gotten dog treats as well?
I would say that is likely compensable because the purpose of the trip and the reason for the travel was to nourish himself, and just like in Bergman's. Now, there is a possibility, depending on does he hang around the store for an hour and then do some shopping and do some things, that there might be a certain point where it's sufficiently attenuated that's not. There is another case that is somewhat off point but dealt with that issue to some extent called Joplin, where Joplin had to travel to go to a defense medical examination. And on the way back, Joplin stopped, I believe, at a bar for several hours and then was hurt leaving the bar, I believe driving already. But they said it was so long of a deviation that it cut the causation. And so it really does depend on the facts of that.
And that's again, a good capture of the struggle that cases like this present, where you have traveling employees, and it seems to me that Bergman, quoting Larson, used the concept of a distinct departure from, the employee's sort of purpose on behalf of the employer. Is it your position here that the ALJ erred in not finding this was a distinct departure from his work focus?
Yes, it was a personal errand, and the terms that I see in the cases, and I know I'm looking at Peterson, was that you're talking about necessity. Was it necessitated? And number two, did it serve the employer in a roundabout sense in that, if you're going to have an overnight trip, you've got to sleep somewhere. And so if you're injured while sleeping, you're covered. But if you're injured while doing something that's distinctly personal, as in the Edwards case where he was injured by drowning in the hotel pool, then that is not. And similarly here with Mr. McChesney, since he was on a clear personal errand to get treats for his dog, that is distinctly different from anything that serves his employer's purpose and therefore should be excluded from coverage.
Was there any evidence that he had had any other opportunity to eat during the day?
I don't know. I don't recall evidence of that. Like I said, if he had been going into the Walmart to eat, I would say he is covered. I think Bergman's clearly would be on point with that.
Walk me through it. So he starts his day, he drives, he starts his day at what time? And he drives over and he stops where? Walk me through chronologically how it happened.
My understanding is that he had already done his duties at that Walmart in the back.
No,
And-
no,
I'm
no.
sorry.
Beginning of the shift.
Oh, I don't have all the details of that, except that, he may or may not have eaten, I don't know.
Is there
Like I
any
said,
evidence that he had eaten
I don't know.
or that he had stopped anywhere else?
I don't know. I don't consider it relevant because that was not what the purpose of the trip was.
So if he had not stopped anywhere where he had access to food, that's not relevant to the fact that he stops at one place that is essentially a grocery store?
Well, if that was the purpose of the trip, then it would be covered. That was not the purpose
Well,
of the
I
trip.
bring it
so
up only
should not.
because we had this discussion about whether, and I don't know what exactly he meant when he said might have eaten, how he expressed himself. But if he stops at the only place where he has access to food, then wouldn't that be something for us to consider in answering the question of whether this was so remote a deviation from his customary practice?
Well, I don't think that the remoteness of the deviation matters. I think the fact is that, is it what the case that I've seen before, I think the correct word is distinct. Is it a distinctly non-work related thing? And like I say, was it both necessary and did it serve his employer's purpose by doing things that you need to do to survive to get through the day, whether it's sleeping or eating or taking medicine or something of that?
And let me ask, I think the record indicated he left, given some mechanical issues, left the Phoenix area about 10:30 in the morning. Injury occurred about 3:45-ish, something like that. And again, I'm just looking from the ALJ's decision that says the applicant testified that he had not yet taken a break when he arrived at the Flagstaff Walmart store. Is that consistent with your recollection of the record?
It is, and I have no recollection as to whether did he have breakfast before that, did he eat on the way on the trip, was he eating while working at some point? I don't recall there being evidence that really delved into that in depth.
And again, the breaks, at least according to the applicant's testimony from the ALJ, in the 6th hour of the workday, he is recommended to take a 30-minute break. Does that sound about right?
Yes.
And then federal law, there's a federal law overlay on what's
Right.
required, right? Okay, thank you.
Yeah, I was more concerned with, what he actually did, what was his intent, what was his purpose, as the testimony elicited. And I think that it's clear it was a personal errand. There might have been some mixing, maybe, but we don't know. It's very speculative.
Well, we don't have to speculate. The evidence tells us that he had not taken a break.
Oh, I don't mean that part, Judge. I'm sorry. What I was referring to is that whether he was going to do something besides the purely personal errand that's distinct from his job duties or attendant to that, that's the part that is very unclear. His testimony saying, well, maybe I was going to do something else while I was in there was something that was speculative, and it was never really developed as to, well, were you probably going to eat lunch and that you didn't eat lunch before or have something to eat so that you were almost certainly going to have something to eat. That was not developed. But what was developed was that the clear reason that he was where he was and when he had the accident was that he was going to do something that was a distinct personal errand.
So is the record clear? Was he on break or not?
My understanding, he was on a break, and sometimes you're covered on a break depending on what you're doing. Like I say, Bergman's was at lunch.
But you could go walk around the parking lot if you wanted to stretch your legs. If you wanted to walk around and you step in a hole, that's covered or not?
Wow, that's a tough one. I don't know the answer to that. I haven't seen that fact situation come up. I think that it would have to be more than that in order to deny coverage for something of you're just walking around and doing something when you're traveling. If you're off premises and you're local in a fixed location and you just happen to wander off premises and you have an accident, I would say clearly you are not covered. Now, when you're traveling, there's a bit of an expansive thing, but again, as Peterson talks about in quite a bit of depth, is it necessary? Does it benefit the employer's business? And those are what we have to focus on. And it doesn't have to be some huge deviation. It just has to be distinct.
But don't we review the evidence in the light most favorable to sustaining the award and affirm if the evidence reasonably supports the award? And so in looking at the evidence through that lens, can't we reach the conclusion that if this person is on his break and under time constraints, like we talked about initially, that it benefited his employer? It would be that there's reasonable evidence to support the conclusion that it benefited his employer that he take the shortest amount of time to get to the store so that he could get back on the road.
I don't see, that is very attenuated, and I don't see that there is any evidence that there would have been such a significant difference so that something that was clearly a pure personal errand, that the saving a couple of minutes would have made that much of a difference. I don't see that you still get around the fact that it was a personal errand, and trying to impute that there is a benefit to the employer, I think, is not supported by the evidence.
So do the facts turn for you on the fact that he used the vehicle? It seems like you put a lot of weight on the fact that the company vehicle was used.
No, only to the extent that he is using the vehicle for his personal use, not to do his job duties. But that is really not the controlling thing. The controlling thing is he doing a distinct errand that is personal rather than something that is both necessary and for the benefit of the employer's business. And since it was neither necessary, because it's not clear that he was going to eat or go to the bathroom or something of that sort, and because there is not a clear benefit to the employer, I don't see that. Now, Peterson talks about the fact that if your employer is going to make you stay overnight, then you've got to sleep, and that is a necessary thing. And so there was the necessity, and it benefits the employer because it allows them to have employees do overnight trips for them. And similarly with Bergman's, it benefits the employer to keep him out on the road, to have lunch, and to say that he is still within it.
Well, doesn't a break benefit an employee and the employer? I mean, and both? Doesn't it necessarily?
I don't see how the break benefits the employer.
You don't see how it does?
The break? Now,
a truck driver?
Well, okay, a truck driver on the road, sure. If you're on the road, and there's a 10-hour limit and all that kind of thing under federal rules, there can be a benefit to that in certain circumstances. But mostly what they're doing, obviously, I know that's a little outside our fact situation, is that they are, sticking to a limit only because the law requires it, and sometimes they don't stick to that. I am out of time,
counsel?
so thank you.
Thank you.
Thank you very much. All right.
Good morning, Your Honors. My name is Dennis Kurth, and I'm with the law firm of Snow, Carpio, and Wheatley. I'm assisted today by my co-counsel, Mr. Joseph Durst, who's also a member of our law firm, and I represent Gordon McChesney, the respondent employee. It's been pervasive all through the petitioner's briefs that they're emphasizing that, dog treats and personal errand, but that's really not the way to analyze this case under the prevailing case law. It took a lot for the petitioners, even in their briefs, to get to the point of recognizing that Bergman might have some application to this case, but Bergman is the law on this case for a traveling employee. And of course, this traveling employee falls somewhere between just a local traveling employee and an overnight employee. So it's even more important, I think, that he has expanded coverage in the course and scope of his employment. But this argument and this focus on personal errand just because he's told the boss that he went to get dog treats, I think it takes the focus off what the actual test is. And I think we have to keep our focus on the fact that he was on a break, which his employer said he was entitled to take a break. The second phase that's important is the employer also admitted that it was perfectly permissible for him to get dog treats if he wanted to when he's on a break. So it's not like he deviated from his employment like some of the claimants in the earlier case law, and most of those cases concern taking a trip off the route home. So he didn't do that. What he's doing, it's not even really a deviation, as the court said about the lunch in Bergman. He's doing something that he is authorized to do on his break. It's not a deviation. So then I think the analysis becomes he's not really deviated. He's on a break. He can go get dog treats. Then the question becomes, was the use of the forklift to do that, to get up to the front of the store, a deviation from employment? And under the Bergman test, it would clearly not be, because Bergman, quoting Larson, said that to be a deviation, the activity must be so remote from customary or reasonable practice that it cannot be said to be an incident of the employment. So since he was authorized to do this on a break, and then of course since the judge found that other drivers and even the safety manager, Mr. Ajima, admitted that he used the forklift on 3 occasions to go into the front of the Walmart to get food, that it was it was not such a departure from normal or reasonable activity as to constitute a deviation. So I think if we can get off this personal, you're tying the phrase personal errand with dog treats, and sure, if this was a fixed site employee who went and got dog treats on his lunch hour or something, it would be a whole different analysis. But this is not. And
so let me ask you, I heard counsel for petitioner largely focus on the purpose of the trip to the front of the store. We talked, you heard me ask about, hey, if it was to get food primarily and maybe dog treats, would your argument be the same? And I recall the answer being no. So, and you know, using the restroom for someone who drives the distances that your client does is a necessity of employment. Eating is a necessity of employment. Buying dog treats is not a necessity of employment. So please help me, would you address that argument that petitioner has raised?
Right. I think some of the case law that has said, some of the earlier case law that Bergman quotes said that the trip must be necessitated by the travel. But I think what they mean is in the general broad sense, it's necessitated by the travel. Obviously, getting dog treats is not necessitated by the travel, except to the extent that he was running late. He was running 3 hours late. This was during the pandemic. The stores were closing early. There really was no opportunity for him to do this other than on his break. So I think if we focus on the fact that it's the break that's the key to the thing, just like the lunch was the key to the thing, the key to the issue in Bergman, the break is already authorized, and the employer admitted they knew he was on a break, and then we know that it was okay while he's on a break to get dog treats. Then I think that takes care of the issue about the necessity of getting dog treats.
But you're not arguing, are you, that any injury that occurs on a break is a compensable injury under workers' comp, are you?
In the context of a traveling employee, it could be in that context of a traveling, but certainly not.
Let me ask you a hypothetical. 30-minute break, happens that there is a gun range nearby, and the employee is an avid handgun enthusiast, goes to the gun range, and due to a horrible ricochet is harmed seriously while at the gun range. Would that be compensable from your perspective?
I think it would depend on whether the employer knew about and authorized that type of activity, as this employer had authorized this worker to shop for dog treats on break. So I would think if that activity had not been known to happen by the employer and had been endorsed or approved, and it was a traveling employee, I think it would be that would be what the case would turn on.
Well, and here we have pieces of things that either seem to be authorized or tolerated, but there's no evidence in here that any other employee used the forklift at the back of this store to drive to the front of the store to buy dog treats. There's evidence of using the forklift to go to McDonald's, I think one of the managers testified, as I recall. So, and then we have, I think, a concession that eating and going to the bathroom they have to happen given the nature of this job, but we don't have the convergence factually of those things. Do you agree with that?
No, I don't, Your Honor, with all due respect.
Now, help me understand then.
Okay. And that all goes back to the testimony of Oscar Rodriguez, who I think was the general manager. He's the one, that testimony was quoted in my answering brief. He's the one that said that it was okay for a truck driver to go into the store to pick up a bag of dog treats if he was on his break. So I think that's the key to the evidence that distinguishes that from just going in to get a bite to eat.
And I'm with you, but that doesn't account for the forklift, which seems like the instrument that caused the injury here, right?
And to me, that's the second part of the test. The first is, it doesn't matter if you characterize this as a guy going to get dog treats. Well, anybody would think, well, of course, that wouldn't be covered. But if it was approved by the employer, as Mr. Rodriguez said, and then the applicant, or Mr. McChesney, uses the forklift, that's the next issue. Just as Bergman, the jaywalking. So is the use of the forklift, does that constitute a deviation? Well, I think the judge sewed that up pretty nicely in the award by quoting the testimony of Mr. Ajima that he had used a forklift. See, that was the point. The point was you can't use a forklift to drive to the front of the store. And the fact is there was no evidence that that was actually a rule at all. They said it was a verbal rule. They actually filed an undated document which said you can't use a forklift, you have to walk to the front of the store. But it turned out that document was issued after Mr. McChesney's accident. So it was purely retrospective and didn't have any bearing on the situation. So the use of the forklift, it had been done before to drive to the front of the store, even if the person had used it to get food, which Mr. Ajima had. And Mr. McChesney testified that he had done that before, that other drivers had done that before. Keep in mind that he was the most senior driver there, and he had taught the other drivers how to do that particular bail truck job. So under all those facts, I think it's wrong to look at this from Mr. Slavin's point of view, like, did this benefit the employer? Well, I think Judge Brown was right. Yes, it does benefit the employer for a truck driver who's on the road 11 hours a day to be able to take a break and go into a store during the time of the pandemic when the stores are closing early to pick up his dog treats. So use, it's like, I don't know if Judge Cruz, if you're the one who said that, but these people have lives to live, so you're a truck driver, you get up at 5 in the morning, you get to the yard at 7 in the morning, you're supposed to leave, you're covering 400 miles a day, you're gone for 11 hours minimum every day. I mean, this is a very difficult job. These people have a right to live their lives. What is the problem, especially, and there wasn't to the employer, if he goes into the store to buy dog treats while he's on his break, he's authorized to do it. The use of the forklift as the jaywalking incident in the Bergman case does not, with all due respect, constitute a deviation, something so unreasonable, especially in the light of the way that other people had used the forklifts in the past. So I think if we carefully follow the analysis of the law for a traveling employee, we get over this issue of personal errand and dog treats, and we find that the use of the forklift to go up to the front of the store to get the dog treats was not a substantial deviation. He was where he could have been. He was on the sidewalk going up to the store. His truck was still parked at the store. He was where he could have been expected to be at that particular time. He was not driving to a cabin or going to a bar and drinking. I think we have to recognize that these people who do these kind of jobs that most of us wouldn't want to do at all need some type of leeway to live their lives while they're on the road working these kind of crazy hours. So that's the only other thing I wanted to say was that, yes, it is a benefit to the employer, but that's not the test, whether it's a benefit. He's doing an activity that the employer authorized. So it's not just a personal errand. Fixed site employee going to get dog treats, yeah, a whole different question. But not this guy. He was authorized to do it, and then the question becomes only, is the use of the forklift a deviation? I submit that it's not, in light of the judge made some findings about that and based her award on findings, and I submit to you that those findings and that evidence that the judge cited constitutes reasonable evidence in support of her analysis and her decision that the use of the forklift was not a deviation that would take him out of the scope of his employment.
And just to clarify the point we discussed earlier, the part of the findings were that he used the forklift to the front of the store due to the time constraints that were created by the driving limits, which we know that were increased on that specific day, just to clarify that point from earlier.
That's true. Mm-hmm.
All right, thank you, counsel.
Thank you.
Counsel, we thank you both for your arguments and your briefing. This matter is now taken under advisement, and we will issue a written decision in due course. We're at recess.